It's like marijuana.
Or speech language pathologists.
Yeah, now we're live. James, actually, David Shearer is their next witness. You're very lucky, David.
That's what I hear, Senator.
Yeah, because you get to defend the House position on Section 16566, little b.
I look forward to it, perhaps. So I will, for the record, David Shearer with the Attorney General's office. I'll give a brief statement from our office about this, and then a couple words about constitutionality, and then a couple words about subsection B, which I have been told is a point of interest for the committee. And I'll keep my remarks relatively short because I apologize, I haven't been able to be here for the first part, conflicting committee requests this morning. So I will keep it short, and then I want to be able to be responsive to what the committee's concerns and interests are. The Attorney General's office does support this bill. We think it sends an important message that somebody's identity cannot be used as an excuse for criminal behavior. And we think, and especially on issues of gender and sexual orientation, gender identity specifically, I should say, it is unacceptable to have that be used as an excuse. We think this is an important bill to make sure that all members of the Vermont community are equally protected under our laws. With respect to constitutional issues, I'll just say briefly, I believe others may have been or will be discussing this more extensively. We do think this is constitutional. The US Supreme Court has ruled in multiple cases that states have very wide discretion in determining what mental states can be for criminal behavior. There's a couple cases out there. Montana v. Egelhoff is one case from the 90s that talks about this. It's actually a more recent case, Kansas case around the insanity defense that talks about this as well. So we do think states have wide latitude in that area to determine what mental state is required or can be introduced as evidence, and think we're on secure footing on that. There's even a state case here in Vermont, State v. Searles, which held that knowledge of a young person's age cannot be used as a defense when it comes to sexual assaults against people under 16. And so again, that's another point of precedent with respect to the legislature's ability to set limits on what mental states can be introduced as defenses. With respect to subdivision, so that's the constitutional issue. Moving on to subdivision B, which I understand has been a point of interest here today. The first thing I'll say about it, it's very important to remember that subdivision B is about sentencing. It's not about criminal liability. So subdivision C says at the beginning, the main part of it says the following should not be used to mitigate the severity of an offense. In order for that to be relevant, that means there has to be an offense, which means there has to be a conviction already. So what we're talking about here is sentencing. We're not talking about criminal liability or what can and cannot be introduced in a trial to determine criminal liability. We're talking about how somebody's going to be sentenced, and they're simply saying this can't be considered by a court during the sentencing phase. If there is an issue around some sort of behavior that could have lawfully elicited a response in the nature of self-defense, there's nothing in subdivision A that prevents a trying of that issue. If there was something that elicited, some sort of like a physical touching that could have been an assaultive behavior which lawfully called forth a defense, a self-defense, that can still be tested. And so remember, subdivision B is about sentencing, and I will stop there and happy to take questions.
Senator Sears?
Yes, Senator Penning.
David, I'm curious. Section A is talking about not being able to use it as a defense to the defendant's criminal conduct or to justify the defendant's use of force against another. You said that's not pertinent to a trial? don't I try to use during a trial anything I can as building blocks to try to prevent being convicted? I mean, it seems to
So
me that I would want to raise every possible thing I could think of in trying to present a defense to a jury where eventually I will reach a jury argument at the end of the trial where I'm trying to connect all of my dots. If I raise something in this area, I would see a prosecutor standing up to object and say that is not relevant in this case because of this statute. Why would you believe it's only relevant after there's a conviction?
Again, in subdivision B only is the piece that's relevant after a conviction. Subdivision A is what's relevant to the trying of a case. And subdivision A only eliminates three sort of pieces of knowledge, if you will. And that's the defendant's discovery of, knowledge about, or potential disclosure of the crime victim's actual or perceived sexual orientation or gender identity.
How did we miss that B was part of the sentence?
Mr. Chair, could we get
I
this up
wasn't
on the
here for-
screen again?
Huh? Well, I know you weren't here, David, but how did all of us who discussed this, I don't think we're fairly experienced at drafting legislation. I don't think it was clear to me that B is part of the sentencing. And I don't know how I missed it. It's clear that A is part of the charging, right? And the defense can't use the panic that the person was gay or trans in order to lessen the severity of the charges, right? It's part of their defense during trial. It wasn't clear to me that B is part of the sentencing.
Understood, Senator, and all I can speak to is my reading of the statute, and again, that is my read of it, and my hazard guesses about what a court might do, but I think it's fairly clear under my reading of it that that is applicable when you're talking about mitigating the severity. That's mitigation is a term that's commonly used in the sentencing phase of the trial. And again, when you have the term an offense, I do believe that has to be referring to the sentencing phase of the trial.
So we could make that clear very easily,
Yep.
just by adding during the sentencing phase. But I guess, David, I'm wondering do you believe that B could be brought forward during the trial? As written here. So let's say that the defendant argues that there was a sexual advance made. You think that could be brought forward during the trial, nonviolent sexual advance?
Not necessarily. Let me be careful about what I'm saying here, which is that I think B1 in particular, and really I'm going to limit what I'm saying to B1 because I think that's really the point here. B1 in particular could potentially be read to include behavior that could be brought up in a trial but not all such, it could include it. It is not, there's behavior encompassed by B1 that I think could be kept out under A, but B1 could include behavior that, the way it's written right now, it could potentially include behavior that could lawfully elicit some sort of a self-defense type of claim. But there's also behavior in B1 that I think would be excluded by.
So my question would be, if the intention is to allow some prospective subset of B1 to be argued at trial, why couldn't you then have those things considered in mitigation? In other words, it seems to me you have to exclude them from both the trial and the mitigation phase, or neither. Otherwise, it doesn't seem to make sense.
Senator, there's a lot of things that can lawfully be considered during sentencing that are not lawfully considered during a trial. Sentencing is a very broad inquiry.
But here, aren't we doing it the reverse? We're saying that there are things you can talk about at trial, but not at sentencing.
No, I don't believe so. So I think what we're saying here is that there is a potential for some behavior that could be read to be encompassed by B1 that would be allowed to be discussed at trial, and it could be discussed, and then it could not be discussed at sentencing. But again, I think that once guilt has been established, I don't think that is a contradiction or a tension. These are two different phases with different rules about how information.
I guess, but I mean, it seems like what the proposed statute is trying to say is that it's not only not useful to the process, it's injurious to society to allow this sort of defense, and we're going to prohibit it. But to allow it in one phase and not another phase just then disputes that sort of larger message of the statute, to me.
I hear your point. I think one thing that's important to remember is that if we get to a sentencing phase, guilt has been established. So the defense failed. And I think,
but couldn't a judge decide that even though the defense failed in his sentencing discretion, it should still be given some weight, unless otherwise prohibited by statute?
I mean, I think what we're saying here is if the defense failed, then no, the judge doesn't get to consider sentencing.
Okay. So this is how it's commonly done, that something is allowed at trial, but then might be, as a matter of course, prohibited during the sentencing phase.
Well, I think one way to think about it is that things are litigated at trial, and then once a judge doesn't reassess a determination of guilt during the sentencing phase. The judge then looks at a whole universe of issues to decide what a fair sentence might be. And they don't go back and try to look at pieces of it and say, well, I was sort of persuaded by this aspect of the defense, even though the jury wasn't, or maybe, the judge could be the fact finder, but even if, the fact finder wasn't, they don't go back and relitigate that. That wouldn't be a typical way of, I think, for a judge to proceed through a sentencing.
I'm a lay person and without a law degree, but it seems odd to me that that B1 just seems odd to me as written, that we're saying there was a sexual advance, but it can't be used to mitigate the severity of an offense in sentencing, but you can go ahead and argue it in open court. Joe, do you have a?
Yeah, I agree with what you're saying, Philip. And David, if we use Jeanette's earlier example of someone who is approached in a sexual groping of some kind, if you sneaky prosecutors can establish that at that very moment in time, the defendant had just learned that the person was also of a sexual identity that was different than the defendant's, it seems to me that you can apply that and argue to the judge that the reaction was not justified based on this language. And how do you distinguish between what is okay and not okay becomes much more muddied by the way this is framed.
Again, Sorry.
Can I just suggest that we're in the markup phase. And if we want to be in the markup phase, that's fine. But actually, Bryn has a suggestion that might actually solve everybody's problem here. And then again, it may not. So I don't know if you want to go to that. David's already
Sure.
said that he supports the bill. I don't know how you want to proceed, committee. But I do want to get through this morning's testimony. And we
I'd
still
like to
have
hear
several
Bryn's-
witnesses to hear from.
I guess before we break for the day, it would be great to hear Bryn's suggestion.
Yeah, what? With, so why don't we do that? Bryn, can you post your suggestion?
Sure. And I know the committee needs to go through its process, so I was just kind of tinkering with it as I was listening to the comments. So I'll post it now. Give me a second. So you should see, can everybody see on their screen draft 1.1 from today? Okay.
Yes.
So this is, I reworked the language somewhat, so we took B out completely, and instead you just have A that has that original language that provides that there are certain types of evidence that can't be introduced to defend defendant's criminal conduct, establish a finding of diminished capacity, or justify defendant's use of force against a victim. And the types of evidence are as outlined here in 1 and 2. So the first is that language that originally appeared in A, in the beginning of A. So evidence about the defendant's discovery of, knowledge about, or potential disclosure of the victim's identity. And then here, if you look at line 15, this is where I've incorporated that that language that was in B1, including under circumstances in which the victim made a non-forcible, and I changed that from nonviolent to non-forcible, just another idea, romantic or sexual advance towards the defendant. And also subdivision 2, you also can't introduce evidence of defendant's perception or belief, even if inaccurate, of the gender identity, or sexual orientation of a crime victim in order to establish a defense or justify defendant's conduct. So that I did this in an attempt to include that category of evidence, evidence of a unwanted sexual or romantic advance, but in the context of the types of protected categories you're trying to address.
Thank you. So, thank you, Bryn. Committee, any questions about this?
I like that better, but it's the phrase non-forcible sexual advance. Nobody has really yet defined what that means for us.
Well, it's better than non-violent romantic or sexual advance.
Yeah. But so for me, it might be I like this construction better. But does non-forcible sexual advance include things that cross the line into any form of criminality? So
Okay, well,
does that make
let's
sense?
go to David Shearer. You want to look at this further and come back to it next week, David?
Senator, that might be the best way forward. I would just, my initial thought, I'll just throw out there and then return to it more substantively next week, is I understand that the key concern here is around defining and what is defined by either nonviolent or non-forcible. And Senator Benny can correct me where I'm wrong, but my sense is that in envisioning something like a lewd and lascivious conduct type thing, where it's not, would that be capture type of activity? Could you do something like that and have that be sort of outside, would that be captured by nonviolent or non-forcible? I think that's the concern. Sort of give one example where we might have a disjuncture between what we're trying to retain as a defense and what we're trying to outlaw as a defense. And my worry would be that if we include that language in something that is not specific to the sentencing phase, then we are potentially putting ourselves more squarely in the territory that Senator Benning is worried about. That's an initial response. I hope I didn't confuse things further.
No, I think what we're going to do is we're going to move on to our witnesses. And then when we come back to markup, we'll work from Bryn's newest draft.
Dick, just before David leaves, David, the other thing I'd ask you to chew on is the fact that this now removes the distinguishing characteristics of A and B, where one area is governing the trial point and the other is governing sentencing. This seems to eliminate the sentencing discussion altogether. I also wonder why we even need the language on 15 and 16 at all. But
Well, that's my thought. If you look at the bill as passed the House and you got rid of B1, I would be fine with it. And I think it does everything we've said we want to do.
yeah,
Those are two alternatives to look at next week. Thank you, Bryn. Very helpful. All right, James Pepper, state's attorneys and sheriffs. How do the sheriffs feel about this?
The transport deputies are very supportive. For the record, James Pepper, Department of State's Attorneys and Sheriffs. The state's attorneys are supportive of the as passed version, as passed by the House version of H-128. Our testimony in the House really was that this bill kind of is an alternative way of strengthening certain aspects of the hate crime statute. In those instances where a prosecutor cannot prove the enhancement beyond a reasonable doubt, what this bill would do would just prevent that same defendant from turning around and trying to avoid culpability or mitigate culpability because of the identity of the victim. This bill is saying that, certain characteristics are just categorically irrelevant to the crime. So the state's attorneys really do support this bill. And I'm just going to talk about the concerns that I've heard this morning about subsection B. And the concern that I'm hearing is that this sort of conduct, the kind of non-forcible, non-violent advances, sexual or romantic advances, those could be criminal in themselves. And they also might elicit a physical and possibly justified physical reaction completely unrelated to the sexual orientation or the gender identity, and therefore should be admissible. I know that the House committee struggled with the language here a little bit. There is some revisions to it, and this idea of non-forcible, non-violent. I think we're willing to work out. I think that there are ways, maybe saying non-criminal or non-physical or something along those lines might be better. But I would really want to just take a moment with the lead sponsors of the bill and some of the other witnesses here today to talk about what the ramifications or implications of that might be to those groups. But I think that there would be a kind of a way forward, relatively simple way forward that might address some of the concerns that have been raised here today, which I think are legitimate.
One of the suggestions is removing B1 completely.
Right. I think I would really just, I hate to do this because I know where we are in the session, but, talk with the Defender General's office offline and some of the lead sponsors of the bill and think about, what would it mean to the underlying intent if we remove B1 or change that non-forcible or non-violent to a different word that kind of allows for some evidence to come in that probably that would already be excluded under A. So it would be kind of a different category of evidence that might be totally unrelated to sexual orientation or gender identity.
Thank you. Questions for James Pepper? James, thank you once again for appearing before us, and we appreciate your thoughts.
Thank you.
Ingrid Jonas, support. Gotta get your title right now.
Not for long.
Oh, not for long. Uh-oh. Are you changing her title, Senator White?
She is.
Oh, she is. All right. Major Ingrid Jonas. I'm going to leave it at that. Vermont State Police.
Good morning. Thank you, sir.
Good morning.
For the record, Ingrid Jonas with Vermont State Police. I'm a major in our department. I appreciate the opportunity to provide testimony on this. This is the first time that I've been in to speak on this bill. In summary, Department of Public Safety strongly supports the bill. You've been speaking this morning mostly about sort of the criminal justice further down the line than what we would do, which is investigating crimes motivated by hate or bias. But this bill, should it become law, would actually help strengthen our ability to investigate, because we see it as a way to remove obstacles and build trust in communities that otherwise are understandably wary about coming forward to report hate-motivated crimes. So we feel like it's really about leveling the playing field, and when we're able to sort of remove obstacles for crime victims, we do a better job investigating. And so it does have an impact for us as well, as in the investigation portion of this type of crime. So we are in support.
Thank you. Have you had many complaints?
So, we keep track of cases that may have a bias motivation to them, and we do that in the way of coding a case in that way. So I did a quick check in 2020, and in 2019, I was able to find only one case in each year that was coded specifically for hate motivated by, anti-transgender. I'd have to dig a little bit deeper to tally up all of the cases that might be something that you'd be covering with this bill. There's certainly a number of cases that are coded as motivated by hate or bias. But I think that that we need to increase the ability for people to feel comfortable coming forward, and then having investigators trained to identify that this type of crime seems to be motivated by hate.
Your theory is interesting, that you feel this would help in investigations because people we're removing an obstacle, that the reason that you were beaten is because you're gay and you made advances to somebody who didn't want those advances, and therefore it's okay to be you.
Correct.
And so you feel like a lot of people might not report based on that.
Well, I think that there's mistrust in the system, and people are wary whether we're able to protect them, or we might be part of the problem ourselves. And I feel like this law makes it clear that we, as a state, care about all of our people, and we remove obstacles and make it clearer that people can come forward. In particular, people who are sort of unfairly driven into the shadows, so to speak, around the types of crimes they've experienced.
So there may be more cases reported, not necessarily more cases, but more reported because of laws like this.
Correct.
Thank you.
You're welcome.
Other questions for Major Jonas? Well, we look forward to finding out what the next position will be.
Thank you all.
Thank you. Senator White, you must know something.
Nah, just guessing.
Senator White always knows something.
Yeah, she's.
Thanks all.
Thank you. All right. Rebecca Turner, head of the Appellate Division, the Office of Defender General, is our next witness. Rebecca, welcome to Senate Judiciary. Well, since we've seen you.
Thank you. It has been a while, and I too think this is first time I've been before the committee this session. So
I think so.
Thank you. For the record, Rebecca Turner, Supervising Attorney for the Appellate Division of the Office of the Defender General. I spoke with House Judiciary Committee members about this bill, and share and repeat the Office of Defender General's position is that we oppose this bill, and I'll explain for a few reasons why that is. I think, though, that it's useful to sort of step back and make sure that I make clear what problem this bill is trying to get at, and if so, does a ban on gay panic defense, an absolute ban, fix it? Now, undeniably, unquestionably, there is a problem of violence against LGBTQ people and its opponents. So that's not in dispute whether or not that is a problem. I think the question really is, is the use of this defense in criminal proceedings a problem? Is it used at all? And my understanding, talking with practitioners, that defense practitioners, is that they couldn't recall it being used, although I listened in earlier on to discussions that there was a recollection of at least one case, perhaps, where it was brought up. The other point, though, is if the defense is used, and I think the prosecutors shared with the House Judiciary that they were not aware of the defense ever being used in any Vermont criminal case. If the defense is used, is it resulting in acquittals? Is it resulting in lower sentences? I think that's the problem, that if we had that problem, this bill would be addressing. And I think that there may be lots of reasons why the defense isn't being used here. I think strategically, from a defense perspective, it could certainly backfire on the defendant. There is no data, as Susanna Davis shared earlier, that I'm aware of tracking whether these defenses are used in this state. I did, preparing for my testimony, find one scholar, W. Karsten Anderson, professor of criminal justice at St. Edward's University. He's been tracking the use of the gay panic defense nationally, and specifically in homicide cases, because the FBI, as he shared, is not tracking this data as well. And what his finding has been is that the sentences, when these defenses are allowed in and used, that the sentences, that the majority of those cases, again, this sort of narrow group nationally, where they're used in murder cases, results in a much more severe sentence. Again, the question that I come back to is, what problem does this bill address? I think that we should pause a moment and know that there are rules of evidence that establish the initial threshold requirements to getting something like this in that work against these defenses coming in, as a matter of fact. And of course, the adversarial process, where the prosecutor can certainly have the opportunity, full opportunity to challenge the relevance, the prejudice, any other foundational requirements for a particular defense, the prima facie requirements for insanity, the provocation, all of those, whether or not self-defense, whether or not those have been met. The judge is there acting as the ultimate gatekeeper, independent, applying those rules. And then, of course, the jurors who hear the evidence, if it comes in, and whether they accept that as a basis to excuse the charged conduct. And I think all of those work together to establish where we are here in Vermont, which is that it is not a problem. Earlier, the committee brought up the case of Matthew Shepard, and that was a 1999 case. And what's interesting about that was that the defense attorneys there did try to bring in a gay panic defense, but the judge, acting as gatekeeper, would not let that in. So again, the current mechanisms in place are already preventing this from coming in, and certainly from it resulting in a problem. So then I started wondering, well, if there's not a problem, is it something that should be proactively done, right? Again, I understand the message, which is that we need to send a message that we can't tolerate this kind of specific hate, right? That it doesn't fall within our society's norms. I think in the criminal justice world, this raises different issues, but certainly the question is, do we want to try, does banning these types of defenses actually lessen homophobia, lessen the hate that people feel towards this particular community? Now, I think the answer to that, again, so does this bill solve that particular problem? And I think that social research shows, it's particularly when in the racism realm, social research has shown in studies that suppressing discussion of racist thoughts actually backfires, that the way to address asserted racism in a criminal case is to bring it forward, right? And so they can be addressed, so that it can be countered, that you bring this to light to then undercut it. And it certainly flows into the second theory, which is, yes, under the First Amendment, this is the theory under the First Amendment as well, which is that ideas that are harmful, that are hurtful, we don't remove that harmful thought and thinking and attitudes by suppressing and censoring. But again, the First Amendment tolerates hateful, hurtful thoughts, because by bringing it out in the open, it can be challenged, it can be aired and vetted and attacked and, put back. And I think that, again, pushes against this idea that this bill is actually going to fix even the overall goal, again, in the specific context of the criminal proceeding. There is also a due process problem with this bill. It's been alluded to, although the discussion here has been focusing on B1, but A1 going to and banning categorically certain defenses goes to the heart of a defendant's due process right to present a defense. There has been discussion here as to whether or not certain other categories should be included. Again, the concern here being the slippery slope of how many more types of thoughts, inappropriate ideas, reactions are going to be captured. And so I think that is a key concern and undercuts sort of this fundamental principle in criminal law that we only convict where the culpability of the defendant warrants it. We only sentence based on the culpability of the defendant. And so this bill undercuts these foundational principles in our law. It was also brought up earlier in the committee, Senator Benning, in terms of thinking about how this would play out in trial, in terms of, tying the hands of the defendant in terms of not being able to bring this up, but the prosecutor could, both in trial stage and at the sentencing stage. And again, sort of what that means for the imbalance of powers, but also, again, the due process rights of the defendant, that the state has the burden to prove its case. And while there might be a defense there on the conduct, on the mens rea, that the person wouldn't be able to bring that forward, though otherwise admissible under the rules of evidence, relevant and not otherwise prejudicial. I think fundamentally, though, this issue concerns which institutional actor should try to fix this problem, if there is a problem, right? And is it the legislature? Is it the judge, the parties, the council, the jurors? And I think as this discussion this morning has shown, struggling between one scenario versus all the possible circumstances that could arise, a one-size-fits-all rule doesn't work. That this language is much broader than what I think was the underlying presumption of who would be impacted. And just for the record, I think people are presuming a particular race, gender, and sexuality of a defendant, a white heterosexual man defendant, and a particular victim, possibly same sex complainant. But the Office of Defender General's clients include LGBTQ people. And as Senator White's questions in the discussion there, in terms of sort of reimagining who could be captured in this, who could be precluded from raising these types of defenses at trial or at sentencing to argue mitigation, it captures potentially and impacts potentially these marginalized communities. Again, not just LGBTQ, but anyone who can fall within these vague terms. And there's been struggle specifically this morning in terms of understanding non-violent, romantic, or sexual advance. I just want to weigh in on that point, that is very broad and vague language. I read that to include verbal, non-physical conduct, gestures, expressions. Does sending flowers, constitute this? Again, there's been discussions about how this wouldn't be applied broadly, but we know that judges, that attorneys, we look to the plain language of the statute for the legislature's intent, not these committee discussions. They do not control. So the language there is just too broad. And I'll stop there to allow time for some questions.
Good. Thank you for your testimony. I didn't mean good that you're stopping. Speaking of, sometimes we use the wrong term. Thank you for your testimony, Rebecca. I appreciate it very much. It does raise a number of questions. And as you said at the end there, that the language in B is very broad. And I was just thinking of somebody sending a text message to the wrong person telling that they love them. That one senator recently did, sent it to the whole Republican caucus instead of his wife. And could that be taken by that person as a romantic advance? And I think that's what you're describing is things that might have been mistaken. Senator Booth.
Thank you very much, Ms. Turner. So I just want to say of your first 2 points, the first one, that there's no evidence of this being used or minimal evidence of it being used, that doesn't weigh very heavily with me because, as you put it, there is the intent to proactively take it apart as an offense. The other I would say is you questioned whether it would solve the problem of hate against LGBTQ Vermonters in general. I don't think that's its function. I don't think it sets itself out as a statute designed to prevent or mitigate hate. It's attempting to alter the structure of a trial to prevent a certain outcome that we regard as, contrary to society's idea. So I'll go to your other point, which is, and my question to you is this really the Defender General's main objection? In other words, I've known the Defender General as someone who does not like to create new crimes, and in this case, does not like to outlaw defenses. So is the basic objection from your office that this outlaws a defense and therefore narrows the possibilities for the Defender General, and it might be a slippery slope and other defenses would be taken out? Is that really the heart of the objection?
Yes, I think that's a fair statement, that at the heart of it, this bill, again, categorically bans the use of these defenses for all cases. And that broad fix, without the built-in flexibility to approach a case-by-case analysis, which is really where the role of judges and making those calls in the case, so we don't have to think of every possible factual scenario that be captured, that's what we should rely on. But yes, anytime that there is this clear rule of just preventing the defendant from using defenses, and again, defenses that are otherwise relevant, that would otherwise be admissible, right? So again, we are keeping information from whom? We're keeping information from the jurors, from deciding, with being shared with all relevant circumstances, whether the person standing before them is guilty. And so yes, on another level, it's absolutely the Defender General has and does, and it is the policy, not policy, but principle to not support all-out bans on defenses. But fundamentally, it is also a statement on how we don't trust the jurors themselves to select. We don't trust that judges can adequately provide instructions to jurors, that prosecutors can't adequately voir dire potential jurors about what they're about to hear, and how this should not lead to impartial consideration of the evidence. By thinking that we are better serving jurors, again, to decide what are relevant facts or not by keeping something that would otherwise be relevant. Again, this would only come in if it otherwise meets the rules of evidence. And so what the issue with this is it's making a presumption that it can never be relevant. It's keeping it from jurors. I think it fundamentally undermines the trust, public trust in criminal jury trials as well.
We had testimony from Bo Yang earlier, and she made what I thought was a very good point, which is that the rules of evidence are generally rules of exclusion, and a judge applies those rules, and the judge also instructs a jury about things that they may or may not consider. So this would be one more such instruction. Is that not so?
It's an instruction without giving the judge any discretion to otherwise find it reasonable in this particular case, right? And so it's about, and this is again, like fundamentally, who should be making these types of decisions in a criminal case? Should it be the legislature passing these broad, bright line, absolute rules of no admissibility period under no circumstances? Or should it be decided case by case, given the particular circumstances? Again, just the few hours that this committee is sort of thinking about how could this be applied in a given case and what would happen there is just a snapshot of what and why this should be left to the judges to decide, applying the rules in terms of their gatekeeping, initial gatekeeping ways, allowing the individual attorneys in a case to argue the relevance or not. You know, again, many times it's the defense attorney herself who doesn't want, or doesn't want to put this forward because it could backfire. So there were a lot of reasons why, but there may be a case where it is absolutely appropriate and is made, the case is made and the judge makes a determination that is admissible. Again, there doesn't seem to
What
be a
would that
case.
case,
Well,
what would that case be?
I don't
In other
know.
words, well, you're saying that there would be a gay panic defense that was successful. I'm just wondering if you can tell me what it would be.
No, I think that we have to look at other cases in other states, right? Where there's, and again, specifically in the murder cases, where there have been instances where the gay panic defense has been allowed to come in to trial, right? The question then is, what happens? What happens when that's allowed? And I just cited the study from the one professor who found that it actually, the majority of those cases result in conviction and more severe sentences.
That isn't what Boryang testified, the opposite, that she read us 3 or 4 cases where in the sentencing phase, especially, it was mitigated because of the gay panic defense.
And again,
so they wound up with the lightest penalties.
So, and it may be a question of the percentage. I didn't say that it never happens. I said the vast majority, right? And so then the question, and again, I think that there are due process problems when you start to limit defenses like this for defendants. But ultimately, I think it comes back to where will this end? Will there be, and there has already been discussion here in terms of suggesting to expand the other categories of defenses that should be included and banned. Again, I think that this is and has been dealt with by our current system. And those checks, those balances are working, and that we want our jurors to know and have all relevant information before them so they can decide. We want to air these, if it comes into trial, we want them to be aired and tested and challenged and exposed to be unacceptable.
Thank you.
Well,
Senator Sears,
yes, okay.
may I
Well,
ask a question?
Yeah, good, sure.
So Rebecca, thank you. Do we have other kind of categorical or categories of things that are can't be used as evidence? I mean, I know hearsay, but are there other categories like this that you just can't ever use?
I think David Shearer referenced it in the case, and now I don't know if he's still here, case he talked about, which was underage complainant and the age of an underage complainant in a certain case, yes, sex cases. But they're very, and that's one that comes to mind in terms of specific identity of the complainant or characteristics of the complainant. But no, otherwise, I'm not aware.
But I thought that Major Jonas was pretty compelling in her testimony that it would make certain groups freer to report crime, that they don't feel that they can report right now. You mentioned the, and I understand the position of the Defender General, no question about it. I would expect nothing less. But I thought she made a rather compelling argument that people currently feel, well, because of my identity, I don't feel comfortable in going to the police to make a complaint about this behavior, about this beating or whatever it was, hopefully not murder. and that she felt that by having a law such as this, it would make those groups more comfortable in reporting. So when you say you don't know what it would accomplish that isn't already, I would say that might be one thing that it would accomplish.
I can only, and I don't, because we don't have the data, it's hard to respond with something so tangible. I think the analogy I'm thinking of right now is the hate crime enhancement statute. And that is already on the books, and it's different than what is contemplated here, right? This is about removing the ability, but it's effectively setting up for enhanced sentencing, at least the B1 is, right, by not allowing mitigation. But we know that there are underreporting concerns relating to cases involving complainants in the BIPOC community, right? And again, I think the issues there is what is causing the underreporting is certainly bigger than rules of evidence, which is effectively what this would be. I think that is not necessarily driving the underreporting problems. I think there are other issues, trust in law enforcement, and whatnot. So I don't think that there's really the clear connection has been made between this particular absolute ban. Again, this is what judges do all the time in terms of reviewing the various considerations as made by the prosecution, as made the defendant. And then I think the question is should the legislature weigh into this with such an absolute unbreakable rule? And that's where I am suggesting this committee not go there, to leave it to the current system in place, which is adequately working.
Other questions? I do want to get to our final witness this morning. So Joe, go ahead, please.
Rebecca,
Senator Benning.
I appreciate your testimony, Rebecca. I'm now mulling through my head, listening to you and Philip go back and forth. Surely society has a right to insist on behavior that is traditionally now considered anyway something that's just not appropriate. On the other hand, as a criminal defense attorney, if I was representing a 16-year-old child charged with an offense, and that 16-year-old child's entire life was growing up in a family that belonged to the Westboro Baptist Church, should a jury have the question? And should a judge allow consideration of the mindset of that individual is now something I'm trying to wrestle with. And maybe a compromise here is to enable one of the parties in a jury trial to ask for an instruction on this subject rather than taking a blanket statutory statement trying to correct all ills without taking into account any possible reason why we wouldn't want to go in that direction. I'm just interested in hearing what your reaction to that is.
No, I think that is an entirely appropriate approach and a great idea. If there is no reason that such an instruction couldn't be given and couldn't otherwise address the concerns, I think, behind this bill. So there are instructions, and as you know, there's the opportunity of instructions at closing argument. There's the opening instructions that judges often give. And then again, I've talked about the voir dire, the initial questioning of the jurors, the potential jurors at the beginning of trial. So there are lots of opportunities where that can come in as well.
Okay, thanks.
Mm-hmm.
Final questions, comments? Senator Bruce.
Just a comment about that last piece. I would go back to Susanna Davis, and I thought she made a great deal of sense about this statute requiring our society and certain individuals in it to grow up, to realize that it is not a defense to say, I hold ignorant beliefs. It's also not a defense to say my family taught me ignorant beliefs, because all of these panic defenses depend on people saying, in my world, my response, violent response, makes sense. And this statute is meant to say it doesn't make sense. It is not an allowable defense. And if your family taught you that it was, that's a tragedy for you, but it's not going to guide the criminal justice system in allowing you to bring that ignorance into the actual process. So I wouldn't see that as a compromise in this instance, but rather a backdoor undermining of what the bill is trying to do.
My response to that, if I may, is that I think fundamentally it comes down to how do we address ignorance in an open manner to challenge it head on with counter evidence, counter oppositions, right? I think that's where we get to a different and better place. But suppressing ideas, not preventing people from being able to voice and address this, though otherwise relevant. Again, I don't see this as furthering what is trying to be done here. Censorship, whether it's in the courtroom or outside, is directly contrary to the fundamental principles of the First Amendment. And again, there's lots of overlapping ideas here and reasons why this type of absolute ban shouldn't happen. But it does start merging into the First Amendment realm very quickly. And I see this type of reasoning and motivation for this type of bill as supporting any other offensive ideas or thoughts, right? And so where will this end? How many more? So I'll stop.
But we're seeing it right now in Atlanta, Georgia, in my opinion, where the shooter in that case, one sheriff's deputy said he was having a bad day, and others said it was because he's a sex addict, or was it a hate crime based against Asian Americans? And I think that playing out there right now, and we're kind of burying our heads in the sand if we don't recognize that the violence against groups that are perceived to be, whether it was an advance or not, but the violence against people who are gay, or people who are transgender, or people who happen to be Asian Americans, or people who may be Black or any other group, is an epidemic here in America right now. And I don't know, this guy's defense might be that he's a sex addict. I don't buy that. It might be that he, whatever. The fact is that 8 people are dead.
Yes. Speaking.
So that's kind of where I'm coming from in support of this bill, frankly.
I think in response to that, and quickly from a personal note, I'm speaking from both my perspective as being an appellate defender general's office since 2007, but personally as someone who's biracial and who is half Filipino and mother is Filipino immigrant to Vermont. The violence, the current events in Georgia, hate against people because of their race and ethnicity, gender, sexual orientation. This is not something where I am taking some abstract professional view. I just fundamentally don't see addressing these problems as being solved by this particular proposal. We have hate crime enhancement statutes already, and so I think that already addresses those particular concerns. I think when you start getting into trial and start taking away defenses, again, just categorically, right? This doesn't mean it comes in all the time. It just means that we can trust the system as it is now to make those case-by-case calls based on the particular arguments and the situation. That's where this should be and remain, and not this kind of absolute ban. I worry about the other side of it, the sweeping nature of this rule and where it could go next.
Thank you. Appreciate your testimony, Rebecca, and hopefully you'll join us when we do the markup at some point next week, I hope, of the bill. Our final witness this morning is Jessica Barquist, Director of Policy and Organizing, Vermont Network Against Domestic and Sexual Violence.
Thank you.
Morning,
Thank you
Jessica.
Good morning, senators. Thank you for the invitation to testify today, and I will try to be very brief. For the record, my name is Jessica Barquist, and I am the Policy and Organizing Director for the Vermont Network. The Vermont Network wholeheartedly supports H128 as written. We're proud to stand with our member organization, the Pride Center of Vermont, in support of this bill. Domestic and sexual violence is often rooted in gender bias, and gender-based violence disproportionately impacts gender-oppressed people, including women and members of the LGBTQ+ community. So this bill specifically addresses gender-based violence as it relates to LGBTQ+ individuals who are more likely to experience hate crimes. While they make up just 5.6% of the US population, in 2019, 18.8% of hate crimes targeted people for their sexual orientation or identity. Research shows that 1 out of 5 lesbian, gay, or bisexual people living in the US will experience a hate crime in their lifetime, and more than 1 in 4 transgender people will. And you heard from my colleague Kim Jordan this morning that in 2018 and 2019, 43% of the individuals who accessed services from the Pride Center Safe Space program experienced hate violence. So while it is very true that our data is undoubtedly limited, we do know that it does happen here and that Vermont is not an outlier on this issue. And the LGBTQ+ panic defense is rooted in homophobia and transphobia, and basically asks the judge or jury to find that an individual's identity or expression is to blame for a defendant's violent reaction. This defense attempts to legitimize and excuse violent behavior against LGBTQ+ individuals. This dehumanizing legal tactic has already been banned in 9 states, and legislation to ban it has been introduced in 10 additional states, as well as Vermont this year. And traditionally, this defense has been used in 3 separate ways to mitigate a case of murder to manslaughter or justified homicide. And I am going to read about these 3 different ways that which this bill addresses. And this is directly from the lgbtbar.org website. So the first is the defense of insanity or diminished capacity. So the defendant alleges that a sexual proposition by the victim due to their sexual orientation or gender identity triggers a nervous breakdown in the defendant, causing a panic. And this defense is actually based on an outdated psychological term, the gay panic disorder, which was debunked by the American Psychiatric Association and removed from the DSM in 1973. So sadly, while the medical field has evolved with our increasingly just society, the legal field has yet to catch up on this. The second is the defense of provocation. So this allows a defendant to argue that the victim's proposition, sometimes termed in this bill as a nonviolent sexual advance, was sufficiently provocative to induce the defendant to kill the victim. Defendants claiming a provocative advance stigmatize behavior, which on its own is not illegal or harmful, but is only considered provocative when it comes from an LGBTQ individual. So that gets at what you all were discussing this morning around nonviolent, and it's really talking about, we're not talking about a violent approach or advance that is then met with an understandable violence in return. This is really talking about situations in which there is no aggression or assaultive or criminal behavior. And then finally, the third is the defense of self-defense. So defendants claim they believe that the victim, because of their sexual orientation or gender identity, was about to cause the defendant serious bodily harm. This defense is offensive and harmful because it argues that a person's gender or sexual identity makes them more of a threat to safety. In addition, LGBTQ+ panic is often employed to justify violence when the victim's behavior falls short of the serious bodily harm standard, or the defendant used a greater amount of force than reasonably necessary to avoid danger, such as using weapons when their attacker was unarmed. So in closing, I really appreciate the conversation around the clarity of the language in subsection B this morning. And I do look forward to working offline with the state's attorneys, defender general, and sponsors and other stakeholders to clarify this language and uphold the really important intent of this bill. This bill has been requested by the LGBTQ community here in Vermont as a measure that would make them feel more welcome and safe in this state. And this is really an opportunity for Vermont to live into its values and stand for our LGBTQ+ friends, families, and neighbors. So we support the language of this bill as written and think it is a really necessary step for Vermont. Thank you.
Thank you. Could you repeat the second, the one that went towards non-violent romantic or sexual advance?
Yeah,
What
absolutely.
you said there. Thank you.
The defense of provocation allows a defendant to argue that the victim's proposition, sometimes termed a nonviolent sexual advance, was sufficiently provocative to induce the defendant to kill the victim. Defendants claiming a provocative advance stigmatize behavior which, on its own, is not illegal or harmful, but is only considered provocative when it comes from an LGBTQ+ individual.
Or perceived to be.
Exactly.
Thank you. Senator Baruth.
Thank you very much, Jessica. In your first run through on B1, you hit on a point that had occurred to me just a few seconds earlier, which is you said it wasn't criminal conduct. So I had sent Bryn a note earlier suggesting that we use non-criminal along with non-forcible. That would take care of my objection, just clarifying that the behavior, whatever it was not criminal. It didn't therefore invite any kind of criminal behavior. So I thank you for that. And when we get to the point where we're wordsmithing that language, that's something I'm hoping we might think about.
Thank you. Other questions for Jessica? I'm still troubled by B1. Clearly, if it's meant to be part of sentencing, then it ought to be clear it's part of the sentencing process.
Mm-hmm.
If it's meant, I mean, I think that's part of where the problem is. And I understand what you're saying about the conduct and using it as an excuse for their behavior. We use murder as a term, but it also could be, a violent beating. It could be forms of bullying, whatever. And then using that as an excuse. So I certainly don't want to make excuses, but the way that David Shearer described this section, it's about the sentencing process. And I'm not sure. So we need to figure that out. So any other questions for Jessica? Okay, thank you very much. We've got about 5 minutes to continue to discuss where you want to go next week? Are there other witnesses the committee would like to hear from?
I just will say that I always get very nervous whenever we do something that's a categorical directive. And I was my thinking is all muddled now after Rebecca spoke with us. Because I do understand, and I go back to, probably shouldn't do this, but to when the Defender General talked to us and he had the 4 questions, and are there other ways of dealing with this, and will it have the impact that we want? And I don't know in this case. So.
Well, but when we did the hate crimes when we added hate crimes and worked on that, maybe Bryn, it would be helpful to just have a brief overview of hate crimes next week, and the statutes that we developed to enhance penalties for hate crimes. I think that was, as I remember it, that was somewhat of a direct result from the Matthew Shepard case and other cases. I may be mistaken there, but I remember that led to hate crime legislation on house and other events. But in terms of the this particular defense, because the the perpetrators in that Shepard case used that panic defense.
And I just, my concern is not around the hate crimes, because I think that's a, you can introduce that, but this is
if we look
a
at
prohibition about introducing.
Understood. But
anything.
if we look, what for me would be helpful is to go back to when the general discussion about when we did the hate crime statutes and continued to add to them. But when we did those statutes, there was a reason, it was a response to this type of behavior where people were targeted because of race, sexual orientation, etc.
I'm beginning to sense a real distinction is needed here between the trial phase and the sentencing stage. I'm more comfortable with this language preventing a defense from being presented during the trial than I am with denying a defendant the ability to make whatever mitigating argument they want to make and leaving it to the judge to decide whether that's appropriate or not. So I'm really trying to bat back and forth the distinction between those two phases. And if we're going to allow it for gender and gender orientation, I think it is also wise to include a study to broaden that to other categories that are now currently protected classes. I guess I'll leave it there.
I guess, Mr. Chair, if I might.
Yeah, go ahead.
My problem with that is it seems to me that hate crime legislation already prevents a defense where somebody says this person was from this protected category and I learned that and therefore I attacked them. The hate crime legislation already prevents that categorically. What this is saying is that in this particular instance, there was an additional category of discovery somehow, or revelation that produced some kind of change in me, and I panicked, and it it dismantles that as a defense. So I don't see the need to broaden this to the categories that are covered by hate crimes, because I think that's already met in the law myself.
Well, when we talk about this next week, I thought particularly that Rosanna Davis's comments that this removes a defense that's from a bygone era. Well, I don't have a problem with the concept of the bill. As I've said before, I do have some concerns. I think Senator Benning, your suggestion about at least making clear that B1 is part of the sentencing process and not part of the trial process wasn't clear to me. But then again, I'm not an attorney.
So what B1 says is that it can't be used, that the judge has no ability to look at that when sentencing, right?
Well, that's what they said.
I mean, that's what
Says.
B1 says.
Well, that's what they say it says.
I think
but I
that
mean,
should be
that's-
clarified, definitely.
Right, but that is the intent, that the judge has no ability to,
Evidently, that was
hear
the
from
intent of
somebody.
the
So-
other body.
if I'm presenting my case now, I'm making my statement. I think people get to make a statement at sentencing. And
Yes, if they so
and I
desire.
start talking about that, the judge has to say, stop. You can't say that in here. Right.
Yeah, I'm really uncomfortable doing that. I mean, a judge should be able to weigh whatever the evidence the judge feels is relevant, not what some statute broadcasts ahead of time that they may consider. When you start to do that, you are really restricting the ability of the judge to act in a judge's capacity. That's why we give them the authority to weigh, balance each side as they deem appropriate given the facts in front of them. And when you start to limit that via statute, I get really nervous.
And that's a good place to